Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in the matter of Jimenez versus Jimenez, our civil number 16-0627. Each side will have 20 minutes within which to present their arguments here this morning. Appellant may reserve some portion of that for rebuttal, but it's up to you to keep track of your time in that regard. We have read the briefs. We've been through the record. We've conferenced the case, so we're pretty familiar with the underlying facts and the issues that have been raised. So please keep that in mind as you make your arguments here this morning. We're recording the proceedings both by audio and video. The video will be posted in a matter of days on YouTube. But because we're recording this, I would ask that as you approach the podium to make your arguments that you identify yourself and your clients for that recording. And with that, appellant may proceed.
Thank you.
My name is Candice Orduno-Kraus. I am the attorney for the appellant, Mr. Jose Jimenez, as well as Ms. Irma Garcia, who is the third party in this matter. Sorry, I'm nervous. Your Honor, we are here to ask that this court remand this case back down to the trial court. There are a number of significant issues that I believe needed to be addressed and that simply weren't. Obviously, the biggest one is the jurisdiction. This case was a simple dissolution that turned into quite a big thing. We ended up having the third party, Ms. Irma Garcia, joined in, and some additional claims joined into the matter, which consisted of fraudulent conveyance, conversion, and a trust, constructive trust. It is the appellant's position that the court did not have jurisdiction to bring those additional claims into the dissolution action. A dissolution is specifically there for terminating the marital status. And the court sits in equity, and they're going to sit there and divide the community property and terminate what was originally a marriage.
Ms. Gross, how do you rectify the statement that they did not have jurisdiction with ARS 25-1318A that says that the court is specifically authorized to consider excessive or abnormal expenditures and the concealment or fraudulent disposition of community property when apportioning community property?
Well, I think 2513, while it allows the court to consider this, I think that we have to look at the language of that particular statute. It states specifically that the court can consider this. It does not give the court the authority to render a judgment. Now, the court is specifically there to terminate the community and divide the community property. It is not, under any of the statutes under Title 25, authorized to present a judgment on additional claims. And I think the language, which states that it can consider actual damages and judgments, indicates that, one, these actual damages had to already been proven, and they weren't. Two, there were no judgments presented that showed that there was some kind of excessive expenditure or criminal issue for which one of the parties was responsible for doing, particularly Mr. Jimenez. I believe that the statute just does not provide the court with that authority.
Then why would it be included?
Well, I think the main issue is when the court is sitting in equity, they can consider this. And when they're making a division of the community property, what they need to do is consider, okay, we have some actual damages that needed to be paid out or judgments that needed to be paid out. They haven't been paid out. So what I'm going to do is I'm going to divide the community property and make sure that the other party is compensated if they are claiming no liability to those judgments or those additional damages that have already been found. In this case, we didn't have that.
Okay, but how, in practical purposes, would that have come to be in this specific matter?
Quite honestly, Your Honor, I think this case needed to be bifurcated. When you have the fraudulent conveyance and the conversion and the constructive trust, those were mainly directed to Ms. Garcia, the third party, because it was alleged that everything was in her name, that she had converted everything from Mr. Jimenez, and therefore a separate matter needed to be held. Now, you can argue judicial economy, it could all go in within the same case of the dissolution, but if anything, the courts already do not combine a lot of cases. For instance, we don't handle dependency cases within a dissolution matter. We don't handle criminal matters within a dissolution matter. I think what the court needed to have done in this case was set, I guess, kind of like in Jarrow, set a conditional judgment in order to determine those claims with regard to the third party.
So when we talk about Ms. Jimenez, she wants to divorce her husband. She wants her share of the community. And because of the actions of her husband in titling everything in Ms. Garcia's name, now Ms. Jimenez has to file a separate suit to get her share of the community back. Is that how you see this happening?
Yes, I do. You don't have a situation where there's res judicata. You don't have a situation where the dissolution court's authority is going to be usurped by some other court. I think keeping these matters separate simply because of the peculiarity of fraud, conveyance, conversion, and then the dissolution, which is there to terminate the marriage and divide the community property. I think it confuses the matter. I think it would have been prejudicial. It was prejudicial to my clients.
So you don't see any fault in the logic that in a divorce action, the bad actor gets the benefit of the good actor, and I'm just using this hypothetically. The good actor has to file two separate and pursue two separate causes of actions based on no fault of her own, but the fault of the spouse that is engaging in the fraudulent disposition of community property or concealment of assets?
It does seem asinine. I will concede that. But frankly, because we had a third party that was involved in this particular case, the only way to handle this was to present possibly a conditional judgment, but wait till the interests and the issues of fraud to be developed in a separate proceeding.
This is not the only circumstance where a third party becomes party to a dissolution. So is that incorrect in all of those circumstances?
No, I don't believe so. You have grandparents that are joined in dissolutions for possible third party rights, things like
Let's
that.
set aside custody, because we're only dealing
Yes.
with the community estate. That happens all the time. One person conveys to another person outside of the marriage, that person gets in-pled so that the court can deal with the whole thing. Why is that not the way to handle this?
It's one thing to involve a third party. For example, let's say a mortgage company that has a lien on a marital home, and there might be issues with whatever the mortgage is, and they're going to join the person in, or that entity in. That entity is essentially there just to preserve a right. But I don't think the court is within its authority to say, okay, well, we're going to grant a judgment to this third party because that entity is not part of the marriage.
But isn't the whole purpose of all of filing a complaint and all that is due process?
Correct.
And by bringing Ms. Garcia into the proceedings, you've satisfied that, haven't you? You've given her notice of what the claims are. You've given her an opportunity to be heard in the proceedings. And the judge, and we only have one superior court, can resolve all of the issues, resolving all of the disputes between the parties. I'm not sure why we need to wait and and take another, as you said, an asinine approach to the proceeding?
I think because of the peculiarity of the claims, this is fraud and conveyance and conversion and constructive trust, and to have that muddled within the dissolution, it just doesn't make sense. I think it would behoove the court to wait and actually let those issues play out, whether they are entitled to a jury or what have you. And yes, Ms. Garcia did have due process. She was served. She was able to appear. She had an attorney representing her through the claims. And
theoretically, if she had wanted a jury trial, she could have asked for one.
she could have. And in fact, her attorney did ask for a bifurcated trial, but it was denied. And I don't really understand the court's reasoning, but her attorney had specifically stated that the issues with regard to fraudulent conveyance and conversion and constructive trust had really not been played out, obviously because of the lack of the disclosure issues and some missing information. But I think what her attorney pointed out was we had no experts there to testify with regard to the claims. It was basically just the wife's, Ms. Jimenez's, testimony that, oh, this stuff happened, and I'm entitled to
But your
a
client
judgment.
wasn't precluded from presenting expert testimony, was she?
I don't believe so.
And the disclosure that was missing, didn't Mr. Jimenez and Ms. Garcia admit that they had not been forthcoming with disclosure?
Yes, and even at trial, their attorney said that they might have been remiss with regard to disclosure. They provided everything that they had. I think at one point, one of the attorneys argued that, these are simple people. They don't have the best records keeping, and then what they presented was what they presented. And I understand that Ms. Jimenez pointed that out in her appellate brief, that, okay, we had a disclosure issue. We had Ms. Jimenez's inability to come up with a full evaluation of the business. I think it kind of goes both ways, though, in a sense that discovery was limited to just what was disclosed. We saw no activity by either side of, issue as the subpoenas for missing information. I believe the court pointed out that in the under advisement ruling that there was an indication that things were missing and that things may have been hidden because there was a bank record from 2011 that didn't match a tax return income. So where was that? Where was that activity? But
And wasn't the duty on your client to present that information to the best of his ability at trial, to provide the financial information, to give the documentation? And wasn't your client remiss in doing so?
you could say yes. There was a number of I obviously I can't make up for the record. There were a number of order to show causes and contempt proceedings that were held because of lack of disclosure. A lot of it was prior to Ms. Garcia, and then we had a few other issues once Ms. Garcia was joined in. But if disclosure was lacking, I believe that the wife, Ms. Jimenez, also had avenues that were open to her to help bring in the missing information.
And as an aside, at trial, didn't Ms. Garcia testify that Mr. Jimenez took money out of the cash register, which was never accounted for, and she couldn't control him?
I believe she did, but I don't think that the amount of cash that Mr. Jimenez would have taken from a cash drawer would have amounted to the supposed thousands upon thousands of dollars that were missing.
Frequency, amount, none of that was flushed out by your clients, plural, either of them, was it?
That's correct.
Okay.
That's correct.
Let's move on to the division of goodwill.
With regard to that matter, Your Honors, it is my client's belief that the division of goodwill was essentially, there wasn't enough evidence that, substantial evidence that shows that the division was made properly. There's no doubt that Ms. Jimenez was entitled to some goodwill. Everybody, that's common in any type of dissolution matter. And with regard to this instance, though, goodwill was valued by the court by using both the pre-petition profits and the post-petition profits. We believe that that was improper. The court had before it a number of figures that were presented, albeit they might not have been completely developed, but there were figures, there were tax returns, there were statements that had been provided as to what the income was. The court had before it all of those pre-petition profits where it could have fashioned the goodwill based off of that. It is our belief that when it went into the post-petition profits to make a valuation of the goodwill, that was improper. It was beyond its scope because obviously the court can't divide. It's considered separate property post-petition.
You can certainly look at that to determine the veracity of the claim of whether or not the ongoing earnings stream from the business. I mean, the petition's filed, and all of a sudden the business isn't making as much money. I mean, he can certainly look at that, can't he?
He could look at it. I think the court can consider it, but to actually use it as part of its calculations, in fact, the court specifically used it to compensate Ms. Jimenez for hidden assets. It found it fair to use post-petition profits, subtract the pre-petition profits, and use that value, the difference between those two, to come up with a value for the hidden assets and for the goodwill. So I just think that the court's procedure in doing so was just unfair and improper. I think the court had before it a number of years of profits and tax returns that it could have used to make a valuation of the goodwill prior to the petition being served.
If you wanted the court to make a better determination, why didn't they just make better disclosure?
I think they disclosed what they had. It's unfortunate that we had these problems, but I think the tax returns were pretty sufficient. Those have Schedule C's attached for Ms. Jimenez to evaluate, and we didn't even so much as have anybody go in to testify and say, well, we have these tax returns, we can make a proper evaluation of goodwill, but we're missing this, this, and this. So we need to make some sort of assumption or use this method to come up with a proper and sufficient judgment for Ms. Jimenez to compensate her for that missing information. But with regard to all of these issues, Your Honors, I think besides the jurisdiction issue, there just wasn't much evidence that supports any of the court's findings. I don't believe the fraud and the conversion by Ms. Garcia was fully played out. We had wife's testimony who said, well, she knows that a restaurant can make this much, and so she's entitled to this. And the court and the appellee pointed out, well, okay, So my clients didn't have that great of credibility, but that doesn't justify the division. The wife needed to come up with some kind of prima facie evidence that shows, one, that there was this fraud and conversion, which wasn't met. It was, well, we think, we speculate, and there was really nothing for my clients to rebut because the wife didn't make that approach in the beginning, in the first place. So with regard to all that, I think this case needs to be remanded for the court to reconsider it. And maybe both of the parties were remiss in not seeking out experts to help fill in those missing holes. But I think the majority of what was decided in this case was just decided on a lot of speculation and a lot of evidence that just wasn't there, other than people's credibility, which is improper. One more note. We had noted in my opening brief that we thought it was that Ms. Garcia should have been joined back in 2011 when those temporary orders were issued. And I do argue that in the alternative, it was my fault that I didn't make it as clear. We had percentages that were made between all the parties of ownership. Mr. Jimenez had 75% ownership of the business. Ms. Garcia was only allotted 25%. Joinder of Ms. Garcia should have been done back in 2011 versus 2013.
All right, your time's up. I've got one last question for you.
Sure.
Why should Ms. Garcia be joined during temporary orders hearings when the only thing that will be addressed is the alimony that will come directly from Mr. Jimenez?
Well, that's the interesting part. The temporary orders were issued or were requested specifically for the alimony. And somehow these issues of percentages of business came up when it had never been addressed in anybody's motions. It was mainly to give Ms. Jimenez some income pending the trial. Once the court started delving into we're going to state that Mr. Garcia or Mr. Jimenez has a 75% ownership of the businesses and Ms. Garcia is only going to have 25%. I think she was denied of any opportunity to address that. Now, the appellee states that Ms. Jimenez could have.
We have to cut you off. Thank you.
I appreciate it, Your Honor.
Thank you, counsel. Mr. Cook.
Thank you, Your Honor. My name is Alan Cook, here on behalf of appellee. And if the court doesn't mind, I'd like to be able to refer to the parties of husband and wife. It's easier for me to keep track. But thank you for hearing me today. And I don't mean this in any flip way, but thank you for asking the questions that have always been on my mind about this case. As Judge McMurdy noted, we have one Superior Court in the state of Arizona, and our family law rules, which were fashioned a few years ago to apply strictly with respect to family law, provide for joinder of other parties whose presence and appearance may be essential to fashioning complete relief between the parties. And in response to the questions posed by the court, there is no good reason why these claims can't be dealt with in one proceeding. And Ms. Jimenez had one lawyer, and her husband and Ms. Garcia each had a lawyer. So the appellants here had two lawyers to fashion any request for relief they thought appropriate, to ask for a jury, etc. And they didn't do that. And as Judge Campbell alluded to, Why should wife, who didn't participate in the distribution and expenditure and concealment of all the monies from these businesses, why should she have to go through 2 proceedings to do this when you can do it in one? Certainly, judicial economy would say it should be done in one. And given that, I don't know if the court noted, in the answering brief, I summarized the tax returns that were provided for 9 of the 13 years at issue with respect to these restaurants, and that shows gross receipts of more than $3.4 million. And so when counsel for appellants say these are simple people, I'm saying, wow, that's pretty good. And that's not even all the years. And that doesn't even count the cash somebody took from the register and never mentioned anybody. And the issue that she spoke about a bank record not appearing to be disclosed, well, you're talking about a check drawn on I think it was a Chase account, but the account was never disclosed. They had a check, but they didn't have the account. And I've cited the court to the Worth case and similar cases, Aries versus Palmer Johnson. When a party has it within their exclusive purview to prove a fact, or to prove that something's not true, or to prove what something actually is, and they don't do it, well, the burden's on them to do that. And I don't think it should be a basis for an appeal to come up here and say, gee, the appellants didn't disclose all these records, and therefore why shouldn't get the judgment she's entitled to. I mean, I would submit to you, and I think I hinted this in the answering brief, if anybody's shortchanged in this proceeding, it has to be the wife. And what the trial court did, I think, is what the statutes and the rules authorize it to do, joined a third party. The court's authorized to impose liens on the property of the parties. And it did that to secure the judgment that it made. And I don't know what could be more fair in this circumstance other than the fact that, the trial court had the right to listen to wife's opinion of value of the hidden assets. She has a right to state the value of the community property. And she believed it to be at least $200,000, and the court came in at $122,000, which is 61% of what wife thought was fair. But there it is, and she's not complaining about that. She wants to move forward with her life. So I'm here to answer any questions if I can. I think I did cite to the court innumerable statutes and rules which provide for the court to have the authority and the jurisdiction to do what it did in this case. And I don't see any good cause for setting the judgment aside. Certainly, if the 2 people who had in excess of $3.4 million in revenues wanted to hire a business appraiser to do something different, they could have done that. But the court doesn't even have to accept the opinion of a business appraiser for that matter. I think that what Judge Kenworthy, a judge who served a long time on our bench and done a lot of these cases, did in the matter of coming up with something that he believed to be fair. I think the record speaks for itself that his reasoning is not taken out of thin air. It's based upon not the earnings of the husband for his labors or his compensation for his labors, but rather on the profitability of these businesses and allocating a portion to Ms. Garcia and a portion to the marital community. And I see no error in that. The fact of the matter is the businesses themselves were funded with marital assets, marital property, not the least of which were the recipes that the parties had, the recipes, so their recipes, and I see no error in doing that. And although I'll agree a business appraiser might have done something different, that doesn't mean that what the trial judge here is unreasonable based upon the evidence. And so I would ask that the court award Ms. Jimenez her fees and costs incurred for having to defend the appeal. I've cited the court to the record and how impoverished she is, and ask that the court make that award, particularly considering that the appellants here have had millions of dollars in receipts in their business, and they've accounted for about a fraction of them for the court. I'm happy to take any questions.
No questions, Mr. Cook. Thank you.
Thank you, Your Honor.
Appreciate the the arguments made this morning and the briefs that were filed in this case. We'll take this matter under advisement and issue a written decision in due course. With that, we are adjourned.